Give a very brief introduction as to each of our speakers, and I'm going to state the case, and then I'm going to get out of the way. You'll first hear from Kevin Theriot. Kevin is a graduate of Vanderbilt University School of Law. He's currently senior counsel with Alliance Defending Freedom. That's a nonprofit public interest litigation law firm, and they do litigation in the area of religious liberty and pro-life litigation. Kevin was also counsel in the particular case that you're going to be hearing about, and I'm told, I didn't check this with Kevin, but sat at a table during the oral argument at the U.S. Supreme Court, which was on March 20. Is that right? You were at table. So our other speaker, sort of a hometown guy, Andy Hirth. So Andy is a graduate of MU. Our case today is National Institute of Family and Life Advocates versus Becerra. Becerra is the surname of the California State Attorney General, and that's kind of one of those quirks of federal civil rights litigation. You sue the chief law enforcement officer of the state in their name, but in their official capacity under federal civil rights remedial statutes, in particular one called simply 1983. And the lawsuit has to do with the California Reproductive Fact Act. FACT is all caps, it's an acronym. And there are similar acts in Maryland and a couple of other states, and so there was a split in the circuit, with the Fourth Circuit, the Second Circuit going one way, the Ninth Circuit, this is a Ninth Circuit case, because it involves, of course, California. And so we have this split in the circuit. And the way the California FACT Act regulated and hence gave rise to a compelled speech case, I'm assuming since you're 2 L's and 3 L's, you've had constitutional law, so you'll recall that you not only have a right to speak, but you have a right not to speak, and so we call those compelled speech cases. And California regulated differently licensed medical services centers, different from unlicensed centers. So a licensed medical services center, for example, they would do medical procedures like an ultrasound, they would do pregnancy testing, they could prescribe contraceptive devices and drugs, including abortifacients. And the particular regulation that's the subject of the lawsuit is California required licensed centers to post notices that encourage women to contact the state of California to receive information on free or low-cost abortions. And these particular crisis pregnancy centers, the very reason they exist is for just the opposite message. So you have a conflict here in messages that are 180 degrees opposite of each other. Unlicensed centers, they do not provide medical services, but they do provide counseling. Obviously, a woman in an unwanted pregnancy often needs or wants somebody simply to talk to, somebody knowledgeable about social services, adoption, all of those kinds of things. But in addition to free counseling, they can provide free infant formula, free disposable diapers, car seats, the kind of things that you need if you're of low income and you become a mother. So they provide those kinds of things. And the regulation, again, it's a required message of these unlicensed centers they're required to place disclaimers in large fonts and in as many as 13 different languages in all of their advertising. So in the course of the oral argument in the Supreme Court, somebody brought up a hypothetical about a billboard that simply said, "Choose life." You know, if that was put up by an unlicensed center, was that subject to compelled speech, et cetera, et cetera, et cetera. All right, so just quickly, a couple of things to watch for. Of course, standard of review is always an issue. So is this strict scrutiny or is it intermediate review, intermediate level review? And that's an issue because the kind of speech here is professional speech, sort of like lawyer speech, or in this case, it would be medical services speech, so that's deemed professional speech. Some circuits, including the Ninth Circuit, had said if it's professional speech, we're only going to give it a lower level of review, intermediate review, not strict scrutiny. Now, the Supreme Court has never ruled on that question, so that's an open question. Then, if you're going to give it strict scrutiny, there's an issue that comes under the rubric of gerrymandering, because like any law, there's a general law and then there are exceptions. So there's a question, were there just too many exceptions or too large an exception such that there's gerrymandering? If there's gerrymandering, then of course you get the highest level of review, and it almost never would survive even that scrutiny. And then the last issue to kind of keep an ear out for is these laws are passed to prevent deceit and deception, or simply misleading. And these, of course, are women in crisis, so they're vulnerable to being misled or fraud or deceit. And the question came up at oral argument, well, if that's the problem, then why not, you already have laws on the books, California, for preventing fraud and deceit. Why not just regulate what goes on here by prosecuting for fraud and deceit, rather than a more onerous process, onerous speech, namely requiring this sort of mandatory disclosures. So that's kind of setting up the case for you, and I'll turn it over to Kevin.
I really appreciate you letting me come here. We have a unique opportunity to talk about a case to debate a case that I just was very involved in arguing. I was involved from the beginning in the case, but I didn't argue before the Supreme Court. My boss, Mike Ferris, argued and did a fantastic job. But what's interesting is what I'd like to talk to you a little bit about, how we presented the case, and then how the Supreme Court, at least so far, has viewed the case. Obviously, we won't know anything. We won't know probably until June. But this is a free speech case, and it doesn't matter which side of the abortion debate that you fall on. This is about whether you can force someone to say something that violates their convictions and violates their position. And it's our position that when you do that, then as Professor Esbeck was saying, you get the highest level of constitutional scrutiny, and that's strict scrutiny. When you're compelling someone to say something, there's some case law that says that. You're probably familiar with the license plate case where the live free or die, the Woolley versus Maynard, you may remember from Common Law 1, and a couple who didn't want to have, I believe it was New Hampshire, New Hampshire's motto, live free or die, on their license plate, didn't want to have that on their license plate, and the Supreme Court said, you can't make them. There's the West Virginia Board of Education versus Barnett case, where some students didn't want to say the Pledge of Allegiance, some Jehovah's Witness students back in the 40s, I believe, right, either during or right after the war. They did not want to have to say the Pledge of Allegiance because it violated their religious convictions, and the court said you can't make them do that. That strikes at the heart of the First Amendment. And then more recently, Riley versus Department of Services of the Blind, I've got that wrong, but the Riley case, Supreme Court case, versus, I forget the name of the other defendant, I apologize for that, but it was a blind organization. And they were being forced by the state of North Carolina to disclose that they were professional fundraisers. So not really an ideological kind of case like Woolley and Barnett was, more even in the commercial context, and the Supreme Court says you can't make them do that. That is compelled speech, and so it gets the highest level of scrutiny. And in this case, not only do you have this compelled speech, but you have it targeted against specific speakers. And if you remember from con law, that's one of the no-nos that you do. If you are singling out, if the government is singling out a particular point of view or speakers with a particular identity and treating them differently than other speakers on the topic, then that even, there are some that say that's presumptively unconstitutional, but at least gets the highest level of scrutiny. And the Supreme Court held in the Sorrell case that I believe it was the state of Vermont had promulgated some regulations that said that singled out people who sell pharmaceuticals to doctors and said you can't have access, you can't use this information in a certain way. And even in that context, which was largely commercial, the court said when you do that, you get heightened scrutiny, and Justice Kennedy wrote that and threw it out. So in this case, we have compelled speech both of licensed centers, and these licensed centers really, they're both pro-life. All these organizations are pro-life organizations, and they don't want to tell women that you can go get a free or low-cost abortion at a particular place. And that goes contrary to what their convictions are. In these licensed centers, they do limited obstetric ultrasounds. They provide free clothing for the baby, maternity clothing, formula, that kinds of things. But they are licensed by the state of California. And there are some things that they don't want to be forced to say. The law was specifically designed, the author of the law said that the existence of these pro-life organizations is unfortunate, and so we want to make sure that women have all the information we want them to have. Now, incidentally, in the findings in the preamble to the statute, it says that we have an interest in making sure women know about all their options when they have an unexpected pregnancy, or even an expected one. And certainly there's low-cost abortion, there's contraception, and labor and delivery. They said those are things we want women to know that the state can help with. But in the law itself, it didn't mention labor and delivery at all. The mandatory disclosure says all you got to do is tell them about contraception, about prenatal care, and about the fact that they can get a free or low-cost abortion. So the law on its face was clearly targeting these individuals. The author of the law clearly targeted these type of speakers. And then there's an exception for those organizations that can subscribe to what's called Family Pact. And that exception says that if you subscribe to Family Pact, if you're an organization that can sign women up for Family Pact and refer them to Family Pact, which is a California program that reimburses women for certain medical services, then this law, these mandatory disclosures don't apply to you. And the problem with pro-life centers, like the ones that we represent, was they couldn't do that because in order to be part of that program, you have to refer women for abortion-causing drugs. Any FDA-approved contraceptive, and that violated their conviction. So the law was designed and targeted at these organizations, and it really functioned that way, both on its face and even in its intent. With regard to the unlicensed centers, there's a disclosure that says, it's 29 words, but it just basically says, we're not medical. And the purpose of the law, as articulated by the legislature, was to make sure that women know that they're not coming into a center that pretends to be medical and is really not. They didn't really have any evidence that there were any centers in California that did that. They cited a NARAL report, they cited a UC Hastings report, both of which were not studies at all and actually had no indication of any woman in California having ever been deceived. They weren't able to put on any proof of that. And interestingly enough, at the Supreme Court argument, the state didn't even mention that as a reason for the disclosures. It only said that they had to be disclosed for informational purposes to make sure women had as much information as they could about this. The problem with that is, and incidentally, one more thing about the unlicensed center. Not only did they have to disclose that they were not medical, they had to do so in all of their advertisements. And so as Professor Esbeck, Justice Kennedy proposed a hypothetical at the oral argument and said, so if they put up a billboard that says choose life, do they have to have this 29-word disclosure? And of course we said yes, and after several back and forth between counsel for the state and Justice Sotomayor, believe it or not, she finally got out of it that, yeah, you have to, and she said, well, that's a problem. Because the reason why it's a problem is this disclosure isn't little and tiny words like you see at the bottom of car advertisements. It has to be in the same size font or larger. And so even if you, can you imagine a billboard with choose life and then in 29 words in exactly the same size font saying, I could read it to you, but it basically says we're not a medical center in about 3. So it would clearly cloud out and make it almost impossible to do any kind of digital advertising, especially on something like Google or Facebook where you have 2 or 3 words. It would be obscured by that. Interestingly enough, most people, if you were, your initial reaction to the 2 laws, one requires these licensed centers to refer for abortion, one requires the unlicensed centers to say, hey, we're not medical. Your initial reaction is, well, what's the big deal about the center? Right? You know, they're not medical, they shouldn't pretend to be medical, it shouldn't be a problem. And most people had that visceral reaction, and I would submit to you 2 things. Number one, you need to go and read the Riley case, because in Riley, that was exactly the facts there. They were forced to say something that they didn't want to say, because that would begin a conversation with terminology that they didn't want to use. They don't have any problem telling people they're not medical. You go to the website and they say we don't offer any medical services. That's not the issue. What they don't want to do is in their initial interaction with women, that this has to be posted at the door and inside, and any digital advertising is, it implies that, oh, we're not licensed. It implies that they should be. And when you, and that gives a negative implication that purposely, obviously the purpose of the law is to have women not be, not take advantage of the services offered. And I don't want to take up too much time because I want to leave a lot of time for questions, but I'd like to just conclude with this. That visceral reaction that, wow, the licensed disclosure that makes pro-life centers refer for abortion, that's probably a problem. Not sure what I feel about that, but you know, I may not agree with you, but I think you should have the right to say or not say what you want to say. That's sort of the American way. But the whole thing with non-licensed centers being forced to disclose that they're not licensed, that they're not medical, what's the big deal? And as I described it to you, you know, Riley really says it is a big deal, and especially when it precludes advertising, and especially when it's targeted to these. Not everybody has to do this. It's the statute is designed to really only apply to pro-life centers. The justices were very concerned about that. As I mentioned, Justice Kennedy said that, promulgated that hypothetical initially. Justice Kagan asked specifically about, wait a second, if this is a gerrymandered law, isn't that a problem? And even Justice Sotomayor, after she finally got the counsel for the state to give her a straight answer, says, wow, if they have to disclose that, I'm very concerned about that. So, and of course, Justice Alito, Justice Gorsuch, and Justice Roberts all expressed concern. And so, interestingly enough, the part of the case that many, maybe even you, thought might be the weakest, actually is probably the part of the case that is the strongest, because the state has a very difficult time satisfying the level of scrutiny that it gets, and that is the strictest level of scrutiny. And I'll just conclude with this. As Professor Esbeck mentioned, there are really 2 levels of scrutiny. You get the highest level of strict scrutiny, is whether the statute is narrowly tailored to further a compelling, highest level of interest that a government can have. And of course, that's called strict scrutiny. It's our position that that's what should apply because it's targeted and it's compelled speech. The next level of scrutiny is intermediate scrutiny, and not only the state of California, but also the United States Solicitor General's office submitted a brief and did argue too that it should get the lower level of scrutiny. But it's our position that no matter what level of scrutiny you give it, it can't survive, because both strict scrutiny and intermediate scrutiny require narrow tailoring. And in a nutshell, what that means is the way that the law furthers the government interests has to be in the narrowest way possible so to not infringe upon speech. Infringing upon speech should be the last resort, not the first resort. And in order to make sure that's true, the government has to try other ways of furthering its interest in making sure that women get information, and that women is that they are able to make sure that no deception is going on, and the record is clear that they didn't do any of that. So we're hopeful and cautiously optimistic that we will prevail. Thank you.
Good afternoon, and thank you to the Christian Legal Society, the American Constitution Society, the Federalist Society, and the Kinder Institute for inviting me to be part of this discussion today. So when I was a student here, Professor Esbeck, as he mentioned, was my professor in constitutional law. I'm not quite sure I remember the scowling in the back row, but I probably did do that. But he was also my professor of civil procedure, and so I would be remiss if I didn't at least make a preliminary comment about procedure in this case. This case is on appeal to the U.S. Supreme Court on the denial of a preliminary injunction based on one aspect of the case, which is this speech aspect. There are free exercise claims, I believe, in the case as well. That's not part of the preliminary injunction. So preliminary injunctions are a way of getting an issue before a court more quickly. It has a different level of review that the court undertakes. To establish a preliminary injunction, a party has to show that there is a risk of irreparable harm if the law is not enjoined, and also that they are likely to succeed on the merits. California, the Ninth Circuit has, I think, a slightly different test, but essentially that's it. Are you likely to succeed on the merits, and will there be irreparable harm? There's also a balancing of equities between the two parties that the courts take into consideration. So I think it's important at the offset to say this is a case on appeal from a preliminary injunction. There has been no determination on the merits based on any evidence in this case. The only thing in the record for the court on the when it decided this was the plaintiff's verified complaint. No other evidence. And I think that's really important. The case was going to proceed. It has since been stayed at the district court level pending the outcome of this appeal to the U.S. Supreme Court. But if the case is affirmed or remanded with some other instructions, in the normal course of things, the parties would have the opportunity to present evidence about a lot of these issues that we're talking about here today. And sometimes I think people think that these kinds of laws are pure legal questions, and they can be resolved purely as a matter of law. But much of the time, there are factual issues that are relevant to this decision. And some of those are legal, and I'll talk about those in a minute. But also I want to talk about some of the underlying premises of the argument that Mr. Theriot gave. First, he talked about there being legislative history or legislative statements by the sponsor of the bill that this law was aimed at pro-life clinics or pro-life groups that unfortunately exist. There is a statement by the sponsor who said something to the effect of, it is unfortunate that there are places where women can go and are not told immediately or do not know that they are not getting medical care or that they don't have a full range of services. I disagree with the characterization that the sponsor was saying it's unfortunate that these places exist. I think what the statement was, it's unfortunate that there is confusion about these organizations. And, on that question of whether there is confusion, that was a fact question. As I said, one of the things that could come up on remand, or if it's affirmed and it goes forward in the district court, is whether there is confusion. Whether women who would walk up to one of the plaintiff's clinics here would be likely to be confused about what is offered. And again, none of this is in the record because the only record we have is the verified complaint. But for example, one of the plaintiffs in this case, the Fallbrook Pregnancy Resource Center, its website is www.unplannedparenthood.com. So if you're Googling plannedparenthood.com, this is something that might come up in a web search, right? So that's a possibility. If you go to that website, on the front page of the website, and this is one of the unlicensed facilities, so it does not provide medical care. one of the pictures on the front of the website is a woman in scrubs standing in front of an ultrasound machine in what's clearly a clinic doctor's office of some sort. So again, this is a clinic that doesn't provide medical care, and based purely on the front page of their website, it's easy to see how someone might be confused. So I want to talk about the impetus behind this law, not necessarily just targeting pro-life centers, but targeting or trying to remediate an issue of confusion or people being misled. And I don't necessarily mean intentionally misled. I'm not saying that all of these organizations are out to confuse people. There's also innocent confusion, and it's in the state's interest to make sure that people know what they're getting into. The gerrymandering question. So it is true that if the government passes a statute that is targeted at a specific group of people whose views the government doesn't like, that's pretty problematic, probably per se unconstitutional. And one of the arguments in this case is that's why this law was passed, specifically to target pro-life centers. And the reason you get, or the way you get to that argument is to say there's something like 1,500 clinics or places that provide pregnancy-related services in California. The law does not apply to all of them. It only applies to licensed facilities that focus primarily on pregnancy services or prenatal care and satisfy two of four or five different categories. For example, so this is the exact language of the statute. A licensed clinic is a facility licensed under a particular section of the California Code whose primary purpose is to provide family planning or pregnancy-related services and that satisfies two or more of the following. The facility offers obstetric ultrasounds, the facility provides counseling about contraception, the facility offers pregnancy testing, the facility advertises or solicits patrons with offers to provide prenatal sonography, the facility offers abortion services, the facility has staff or volunteers who collect health information from clients. So anything that satisfies two of those would fall into this category. And you notice one of them provides abortions. So the statute on its face, at least nominally, applies to places that are not pro-life, but places that would in fact provide abortion services. Now there's some carve-outs, two carve-outs in particular that are important. One says this law doesn't apply to any federal clinic. That's an issue of supremacy, not really controversial here. The second one is that it doesn't apply to a facility that receives or is enrolled in the Medi-Cal program, which is kind of like Medicaid here in Missouri, that allows the state to, or allows women to have the state pay for some of these services. And the petitioners in this case have suggested, well, you carve out that, you're going to get rid of everybody except the pro-life groups because in order to be part of that service, in order to belong to Medi-Cal, you have to agree to provide certain services that or at least be able to refer people for services that the groups don't want to provide. Well, that's true, but if you think about what the purpose of the disclosure is, there's no reason to require medical centers that are already part of Medi-Cal, which have a duty under the law to help women find services free of charge. There's no reason to force them to tell people there are services available free of charge, because that's what they're already doing. Right? It doesn't make sense to make them have to make that disclosure. So really what you're left with is groups or clinics that are not part of that system and that are primarily aimed at pregnancy and prenatal care and predominantly cater to low-income women. As the plaintiffs have pointed out in their briefs, the law does not apply to private doctors or for-profit clinics. But again, if the purpose of the statute is to provide information to low-income women who are facing an unwanted pregnancy, they're not likely to be in a for-profit hospital or clinic or in front of a private doctor that only takes insurance. So, I think I would challenge the premise right off the bat that this is specifically targeted or gerrymandered. Also, I think it's important to talk about what the law actually requires based on the kind of facility it is. So there's two kinds: licensed facilities, unlicensed facilities. The licensed facilities, the statement that is required, it's 2 sentences that has to go on media that the clinic hands out or on certain kinds of advertisements, says this: California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at, and then list the phone number. Right, that statement does not say, the state thinks you should have an abortion, or abortion is a good option. What that statement says is, the state has a range of services that it will pay for. If you're interested, here's a number that you can call to find out. It's not limited to abortion. So the plaintiffs refer to this as the abortion referral, the mandatory abortion referral provision. There's no abortion referral here. It is a number that you can call to find out about all services that California will pay for, one of which happens to be abortion. But again, that is something that you have a right to have as a pregnant woman. This is a constitutional right. So the fact that the state is saying this is one of the things that we provide really is not that controversial. All right, so compelled speech. There are lots of laws that compel speech. On my website from my law firm, at the very bottom, it says, choice of a lawyer is a complicated issue and should not be based on advertisement alone. That is there because the Supreme Court requires me to say it on my website. That is compelled speech. Is it legal? Yeah, of course it's legal. When you buy a pack of cigarettes, there's a big thing on the side that says the Surgeon General says this will cause cancer or any list of other things. Right? That is compelled speech. The informed consent laws that we have in Missouri. Right? In order to obtain an abortion in Missouri, you have to go to the provider in 72 hours in advance of getting the abortion. The person who's going to perform the abortion has to deliver the state's message to you. And the state's message is, life begins at conception, and an abortion will terminate the existence of I forget the exact language, but separate, individual, unique human being. Right? That seems like a message to me about the state's ideology. But anyway, I'm out of time, so I wanted to just sort of hit on some major issues, and I'm sure we'll have plenty of time for follow-up questions.
I'd just like to address a couple of things. I think the big difference between the examples of compelled speech that my colleague just gave you and in this case is those involve commercial transactions. And you get, when you're proposing a commercial transaction like with cigarettes or like as a for-profit law firm, then the standard of scrutiny goes way down. And the Supreme Court has held that in cases like in re Primus and NWCP versus Bucket. And then with regard to the preliminary injunction standard, once you've proved that this has a limitation on speech, and that's a really easy bar to get over. The Supreme Court said that if a state regulation makes speech more difficult, then that's a significant burden on speech. Then the burden shifts to the government to prove, even at the preliminary injunction stage, the Gonzalez versus Ocentro says the government has the duty to prove that it has a significant or a compelling interest, and then it's furthering the interest in the narrowest way possible, so that restricting speech is the last resort, not the first one. One thing I didn't mention was another thing about the unlicensed centers, the ones that are non-medical, have to give a 29-word non-medical disclaimer. If they're in a county with multiple threshold languages, which like in LA County, that's 13 different languages, they have to make that disclaimer, 29 disclaimer in the choose life sign on the billboard in 13 different languages. The county, the state AG actually conceded that at oral argument before the Supreme Court. Then, of course, if there is confusion, and the government has the duty to prove that there is confusion, like if Fallbrook's, the website that my colleague was referring to, is confusing women, and it specifically says we don't provide abortion, we don't do medical services, then if it is confusing, then the government has some ways of dealing with that. The law is already on the books without a broad prophylactic rule mandating speech that strikes at the heart of the First Amendment. And then lastly, I'd just like to say that the real problem is whether it's intermediate scrutiny or strict scrutiny, the government has to demonstrate that there's a fit between what they're doing and their interests. So it can't be over-inclusive, it can't include more speech than necessary, and it can't be under-inclusive. That means, for instance, that it accepts all free clinics that don't primarily provide pregnancy services. So if there's a clinic that serves hundreds of women a month, but that's not the majority of what they do, that's only 49% of what they do, they don't have to do either of the disclosures. But a small clinic, like for instance one of our clients, which is pretty small, that only serves 5 or 10 women a month, because that's primarily what they do, then they have to do the disclosure. So if the government's primary interest is making sure women have information, then they wouldn't have exempted out made these huge loopholes and exemptions for these other organizations. So we think that it's pretty clear that this is not only targeted, but it's compelled speech in a way. These centers are nonprofit. They don't propose any commercial transactions, so they're unlike any kind of disclosure by a law firm or on a cigarette package or any other kind of commercial transaction.
Mr. Theriot is correct that if you have a case that is subject to heightened scrutiny, it is the government's burden to satisfy that standard. So either a compelling governmental interest narrowly tailored to meet that interest, or a substantial or significant, I can't remember the exact language for the intermediate level scrutiny. And it is the government's obligation to prove that. And again, in this case, the government got served with a lawsuit and had a preliminary injunction hearing within, I don't know what the amount of time is between when the petition was filed and when that hearing is. I can tell you, when you work in the AG's office and you get a lawsuit, you don't immediately know all the information that the state knows for why it passed the law. That's something you've got to find out, you've got to do discovery on. Just because you represent the state doesn't mean you know as a lawyer up front. You've got to talk to people, you've got to read through the record. Those are things which would come up in discovery, and the state would eventually have the opportunity to present evidence on. It didn't have that opportunity here because we're at a preliminary injunction hearing. This issue of what a non-profit pro-life clinic can be forced to say, again, I think the law is broader than that, but let's assume for a second that is the only target here. In the oral argument, Justice Breyer brought up what he called the sauce rule. What's good for the goose is good for the gander. And there are plenty of states that have laws, like Missouri's, that require doctors to affirmatively state messages that the state authors. In fact, the Supreme Court in Planned Parenthood of Pennsylvania versus Casey, the case that upheld Roe but changed the standard to undue burden, the court actually addressed a statute from Pennsylvania which has that sort of language in it, which I will hopefully be able to put my hands on very quickly. At any rate, it required certain disclosures, like the doctor had to tell you that there were other facilities in the area that provided adoption counseling, that the father could be made to pay for child support. You didn't have to do this on your own. So substantially more disclosures than are required by the California law here. And in that case, a plurality of the court, Casey's kind of a splintered decision, 3 justices said, well, we think that's okay because it regulates professional speech, part of the regulation of the medical industry or medical profession, and therefore it's okay. 4 justices said, we think because it is simply regulating professional services that it gets only rational basis review, and it's okay. So really you have 7 justices saying that language is okay in Casey. You're going to compare what is being upheld in Casey to what is challenged in this case. You're talking about very, very different things. There's no ideological message in the California law. It is merely the state provides several kinds of services. Here's a phone number to call to find out if you are eligible. The law in Casey has a much stronger, I would say, more ideological message. The 8th Circuit has also addressed an issue with almost exact language, and that is Planned Parenthood v. Rounds. I would encourage you to read it. It deals with language almost identical to the language in Missouri, and again, the court there said, no problem, it's constitutional.
All right, now it's your turn to ask questions. You can ask questions to both of them at the same time or directed to a particular one. Yes, right here.
My question is mostly, why do medical centers or these counseling centers need to have the ability to make big billboards that say choose life or pro-choice or whatever they want, when like a charity could do that if it didn't do anything else? If they could, there's other groups that could make these billboards for them or anything like that. They don't have to be coming from this counseling center and these other centers. I don't understand why that's so restrictive on them, because like I don't think that pro-choice centers would have a big thing that's like pro-choice. It's usually just pro-life centers that want to do that. So like there are charities that will do it themselves anyway. So why does it necessarily have to be these counseling centers that make these billboards? And why is this is considered so restrictive on them? They need to put all these warnings on the bottom.
Right. Well, there's a line of Supreme Court cases that says things like you can't have your free speech rights restricted on the grounds that it can be exercised somewhere else, or in your case, by somebody else. So just because somebody else can get out the message doesn't mean that you can be prohibited from getting the message out yourself. And especially when you're a organization that really sits at the heart of First Amendment, like these organizations are. So that's really the answer to that. I understand there are other organizations that can do the same thing, but just like when you want to say something, I can't restrict your speech because your friend could say it for you. So it's the same principle.
Yeah, I was going to, if I can add to that, yeah, I absolutely agree with Mr. Theriot. The rights are exercised at an individual level, not at the level of a group of people who has a particular viewpoint. So just because someone else in your group shares your viewpoint could exercise your right, you still have that right as well.
So my question is for you, Mr. Theriot. It seems from what you're arguing is that this compelled speech does not meet strict scrutiny analysis because it's non-commercial and it's forcing an ideology of the state onto the clinic. Is that like generally?
That's part of it. The ideology is not necessarily part of it, but it certainly it doesn't have to be part of it, but it certainly is with regard to licensing.
Okay, it seems to me that your analysis would then outlaw the very speech that your opposing counsel discussed that are mandated on other types of nonprofit clinics, such as the specific language about that is often mandated on pro-choice clinics.
Right, and the answer to that is it would if those don't do abortion. So a pregnancy, for instance, a Planned Parenthood that only counsels women regarding abortion and refers them out and doesn't do abortion, then they can't be forced to say those things either. The same sauce that Justice Breyer, as pointed out, would apply to them. The difference between this case and Casey, for instance, where an abortion, a medical procedure was being performed, is informed consent. And there, in order to consent to, this is tort law, to consent to a battery on you, that they're going to actually do a surgical procedure on you, you need to have all of the options and you need to know all of the possibilities. And that, therefore, automatically you get a lower level of scrutiny. In this case, first of all, the government of California never said this is part of informed consent. Okay, so they haven't been trying to justify it. If they were, if they said, for instance, with regard to our license centers, in order, before you do a limited obstetric ultrasound, you have to get informed consent, we would say fine. But what they're forcing us to do is give information about services that we don't provide, number one, and number two, that aren't an option to the services that we do provide. An abortion is not an alternative to an ultrasound, and that's the only service we do.
I mean, I understand what you're saying, that some of the language is related to informed consent, but there's language in some states that is not based in generally accepted science. For example, that abortions have links to cancer, and that they're including that under informed consent that, frankly, I don't think has a basis in the scientific and medical community, and that I think that would fit under your analysis of.
Well, certainly there has to be some basis in the scientific community, and of course, we would be certainly fine with giving information about services we provide that is based in science and that is generally accepted. As to more particularly to your point, interestingly enough, even Planned Parenthood concedes that in a case in California, oddly enough, where they were accused of giving this information, that it is at least debatable scientifically whether there's any link between abortion procedure and cancer. So it's a debatable issue. I agree with you that it hasn't been firmly established. But if it's debatable, especially in California when they got to give information about any kind of cancer, whether you're building about this cancer, you think would be okay there.
All the more reason why this case should be remanded for trial to establish a record.
Anybody else?
Yes.
Professor Lee.
So I don't know anything about this area. And I don't know much about these licensed facilities. But when I hear you describe the speech here as compelled, I kind of wonder, like, if the state wants to say to one of these facilities, hey, we only want to give a license to facilities that respect the autonomy of women, and the only way to respect the autonomy of women is to tell them all their legal options. If you don't want to do that, that's fine. You don't have to be in that business. Don't do it. We're just not going to license you. Go do something else and get your message out of the way. Why I guess is this compelled speech when really, why can't the state say we only want to give licenses to organizations that really respect women's autonomy?
If they were to apply that across the board, it would be a much more difficult case. But I would say even then it would be, but they don't. So first of all, the law is targeted. They don't apply this to all doctors that give counseling regarding women, or that do women that are pregnant, or that do ultrasounds. And then the second problem with that is you can't condition a governmental benefit like licensure upon forfeiture of a fundamental right. I know that's a general thing, but in that particular instance it would apply. For instance, in Velasquez, there's a Velasquez case where the legal clinic that they said that gets governmental monies in order to give free services to people who have been that need it. They said you can get this money as long as you don't advocate for a law being unconstitutional. And the Supreme Court struck that down and said, wait a second, you're conditioning the ability to be part of this program, this government program, upon forfeiture of a fundamental right, and you can't do that.